Good morning, everyone. My name is Wendy Perdue. I'm the Dean here at the University of Richmond School of Law. My apologies for the register that my voice is in at the moment. It's my pleasure to welcome you to this really terrific day-long event. It's hard to imagine a more timely topic. The Allen Chair Symposium is named for George Allen, who was a very distinguished trial lawyer in Richmond. He began his practice in the early 20th century and was president of the Richmond Bar. He was fellow of the American College of Trial Lawyers, the first president of the Virginia Trial Lawyers Association. And in 1965, he was named the first recipient of the Award for Courageous Advocacy, given by the American College of Trial Lawyers for representing a black law student accused of felonious assault after a scuffle with police in 1963. That tells you something about the character of Mr. Allen. And in 1976, his sons set up the Allen Chair in his honor, and it continues to this day. The current holder of the Allen Chair is Professor David Epstein, who I think is here. I saw him. And in connection with that, we do an annual symposium this year on the healthcare litigation. As I mentioned before, it's hard to imagine a more timely topic. This program really began last spring after Professor Kevin Walsh published this provocative article suggesting that there might not be subject matter jurisdiction in the Virginia litigation. And that prompted a set of conversations about what other procedural issues might be lingering in the litigation. And as we've talked about it more, it became apparent there were a number of interesting issues. As a proceduralist myself, thought this would be a great topic. So Professor Walsh and Professor Carl Tobias took this on as a project and came up with this program that we came to call Everything But the Merits. Now, it's actually somewhat misleading as a title. Whenever you get into talking about procedure, there is sometimes a sense that procedure is the domain of small-minded little people who worry only about rules and that nothing actually important happens. But lots that's important happens. I'm reminded of Carl Llewellyn's quote in The Bramblebush, where he said in his advice to students, "Everything that you know of procedure you must carry into every substantive course. You must read each substantive course, so to speak, through the spectacles of that procedure. For what substantive law says should be means nothing, except in terms of what procedures say you can make real." So we're going to be exploring a variety of issues that all touch on what can be made real in the litigation. Charles Maitland made an even more dramatic version of this. He said of the forms of action of the common law, the substantive law is secreted into the interstices of procedure. There isn't anything but procedure. What's left over is the merits. So we'll spend the day exploring those procedural structures and how they may impact on the so-called merits. So before I turn it over, I just want to make a couple of thank yous, both to our faculty organizers, Carl Tobias and Kevin Walsh, for their just superb work on this, and to the symposium editor, Amina Qureshi, who's done just a fabulous job in getting this all put together. I know that we have some people participating by webcast. I hope our technology is working. I believe we've set things up so that you can ask questions as well when we get to the question and answer stage. And I look forward to a terrific conversation. So with that, let me turn things over to Professor Jessica Erickson, who's going to moderate the first panel.
Good morning, and thank you all for coming. Our first panel this morning is going to focus on the role of the states in the healthcare litigation. We have a terrific panel of lineup of speakers. All three are distinguished current or former government lawyers, but they bring very different insights into the healthcare litigation. Our first speaker is Duncan Getchell. Mr. Getchell graduated from Duke Law School and then worked as an Air Force JAG officer and as an attorney at McGuire Woods, where he was head of the Appellate Litigation Practice Group. In 2009, he was named Solicitor General of Virginia. The Commonwealth of Virginia has, of course, challenged the constitutionality of the individual mandate, and Mr. Getchell argued on behalf of the Commonwealth in both the Federal District Court and the Fourth Circuit Court of Appeals. Our next speaker is Lucien Marshall from the University of North Carolina School of Law. Mr. Marshall graduated from the University of Chicago Law School and later served as Deputy White House Counsel and Deputy Assistant to the President during the Clinton administration. He also served as the Solicitor General of Ohio. He has published extensively on issues related to the federal courts and executive power, and can offer special insight into states where the executive branch is divided on the constitutionality of the individual mandate. And finally, we have William Brockman. Mr. Brockman graduated from the University of Michigan School of Law and then clerked for Judge Niemeyer on the Fourth Circuit. He joined the Maryland Attorney General's office in 2002 and became the Deputy Solicitor General in 2007. He is currently the Acting Solicitor General for the state of Maryland. Maryland filed an amicus brief in the healthcare litigation arguing that the individual mandate is constitutional. Our plan today is to hear from each of our speakers and then open it up for questions. And I know we're certainly hoping for an interactive panel. I'll turn it over to Mr. Getchell.
First, as a housekeeping matter, I am under contractual obligation to state that much of what you will hear today is contained in an article that has been accepted for publication at Stanford, in an article entitled State Sovereign Standing, often overlooked but not forgotten. That'll be coming out, I think, in January. Is that right, Kevin? Right. And as long as I'm plugging, although we're not discussing the merits here today, there is an article that was published in the Texas Review of Law and Policy in September, authored by the Attorney General, me, and the Deputy Attorney General for Civil Litigation, entitled Why the Healthcare Litigation is About More Than Just Healthcare. On March the 10th, 2010, the Virginia Healthcare Freedom Act became law. This was overlooked or confused by the Fourth Circuit in its opinion because of an intricacy of the Virginia Constitution. In Virginia, if an act passes the General Assembly and the governor offers amendments, and those amendments are accepted by the General Assembly, the bill becomes law without further action by the governor. So the signing that the governor did on the Virginia Act was ceremonial and not substantive. On March 23, 2010, the President of the United States signed PAPACA, and it became law at that point. Virginia, as everyone knows, immediately filed suit that day. We did so because the Attorney General is statutorily required to defend enactments of the Commonwealth. And Judge Hudson, in the District Court opinion, noted that that was, in fact, our obligation. We were immediately met with challenges as to whether or not a state has standing to attack an enactment of the federal government with respect to an area where the state claims competence to regulate and the federal government claims competence to regulate. Now, I would submit that historically this should never have been controversial, because it is absolutely clear that a foundational purpose of the federal court system was to resolve collisions between state and federal power. Madison said so in Federalist 51 by noting that the states were to check the federal government, police the federal government, and the federal government, of course, would also be part of the checks and balances with respect to the states. The question remains, of course, well, there has to be some mechanism for resolving these disputes, but is it the court system? And I think if you read Madison's statement in Federalist 39, where he talks about how it has to be an organ of the federal government, the national government, and I think it's pretty clear that he's talking about the federal court system. Indeed, there's an interesting postscript on this question, because Madison was famously involved with Jefferson in the Virginia resolves and the Kentucky resolves. And those were being used in the South Carolina nullification crisis as supposed support for the notion that South Carolina could nullify a federal act. And Madison wrote a letter for publication in which he pointed out that he believed when he wrote 39, and he believed then, that the federal court system was the proper avenue for resolving these sorts of issues, causing John Marshall to remark that Mr. Madison is his old self again in approval. If you have any doubt that historically a role of the federal court system was to resolve nice, intricate questions of the relationship between the states and the federal government, I would direct your attention to the case of New York versus United States, where Justice O'Connor has a lengthy quote from Hamilton in Federalist 82, talking about how the federal court system would be expected to resolve the questions, the interesting questions that would necessarily arise out of a system which uniquely is a blend of sovereign powers between states and the federal government. And certainly that's what O'Connor said Federalist 82 meant. And this, indeed, this expectation of Madison and Hamilton that the federal courts would engage in the line-drawing function was perfectly realized in McCulloch versus Maryland, which shows every sign of having been engineered as a test case. The act of the Maryland legislature imposing the tax on the notes of the Bank of the United States was an act that could apply only to that bank. There was no other lawful bank in the state of Maryland. There's every sign that it was procedurally developed in a way to reach the Supreme Court as a test case. The parties entered into extensive stipulations of fact that were expressly recited as being binding up to and including the Supreme Court of the United States. It was a very celebrated case, of course. Daniel Webster, Attorney General William Wirt, former Attorney General William Pinckney, all argued for the Bank of the United States. The Maryland Attorney General Luther Martin argued for the state of Maryland. He was with him was Joseph Hopkinson, who with Webster had defended Justice Chase in his impeachment. So it was a very visible, celebrated public case, and there is absolutely no doubt that John Marshall thought that this is exactly how the Supreme Court was supposed to be working. He said, in the case now to be determined, the defendant, a sovereign state, denies the obligation of a law enacted by the legislature of the Union, and the plaintiff on his part contests the validity of an act which has been passed by the legislature of that state. The Constitution of our country, in its most interesting and vital parts, is to be considered. The conflicting powers of the government of the Union and of its members, as marked in that Constitution, are to be discussed, and an opinion given, which may essentially influence the great operations of the government. No tribunal can approach such a question without a deep sense of its importance and of the awful responsibility involved in its decision. But it must be decided peacefully, or remain a source of hostile legislation, perhaps of hostility of a more serious nature. And if it is to be so decided, by this tribunal alone can the decision be made. On the Supreme Court of the United States has the Constitution devolved this important duty. Shortly thereafter, 2 years after the 1819 decision in McCulloch in Cohen's versus Virginia, it was very forcefully announced that federal courts will not exercise jurisdiction where they have none, but must exercise it where they do have jurisdiction. So the stage was not really set, but the trail had been blazed. There was no question but that this is how you resolve collisions between claims of state and federal power. So what happened? What happened was the political question doctrine. And the political question doctrine appears at the end of the 18th century in England in the exotically styled Nabob of the Carnatic versus East India Company. And there the Nabob sued for breach of contract because he had entered into an undertaking with the East India Company. And the British courts said, well, the Nabob is a sovereign, and the East India Company within the territories that it governs is a sovereign, and municipal courts will not entertain disputes between sovereigns. That was not a very prepossessing case to be brought to America with our unique blend of sovereign powers, separation of sovereign powers. But nonetheless, the Cherokee Nation versus Georgia, although it was decided on original jurisdiction questions, had dicta with respect to the political question doctrine. Luther versus Borden, the famous Rhode Island case where Rhode Island was still being governed under its colonial charter, which did not permit of any amendment, so that the lack of suffrage had become intolerable in certain quarters. There was an armed uprising. It was put down. The president had not sent troops. The Congress had seated senators. The Supreme Court said that this was a political question which was beyond the competence and jurisdiction of the court system. Concurring on that point, in what was nonetheless styled a dissent, was Justice Woodbury, who cited the Cherokee Nation and the Nabob of the Carnatic. So now we have a political question doctrine that is in full bloom. The absolute height, I would submit, of the political question doctrine came with congressional reconstruction, when the state of Georgia filed suit under the original jurisdiction of the Supreme Court, saying, we're being abolished. A state is being abolished. Please hear our case. And the Supreme Court, under the political question doctrine, refused to hear the case. So that's where we stood when we get into the 1920s, when Congress passes the Maternity Act. And there was an article in the Harvard Law Review which said some of the states are going to get together and mount a challenge to the Maternity Act, which was a spending power piece of legislation, in which states were offered, but obviously not required, to accept funds in order to administer the act. And the precise question that the challengers wanted to test was whether or not the taxing and spending power is limited by enumerated powers. And that's something that was decided in 1937, that they are not a limitation on the taxing and spending power, but it was unknown country at the time that the Maternity Act was challenged in Massachusetts versus Mellon and Frothingham versus Mellon, which were argued together and decided as one case. And Massachusetts versus Mellon did four things. First, not in any particular order, but it established the taxpayer standing rule, that there's no taxpayer standing in the ordinary case because the effect of an act on any individual's tax is too speculative and too remote to constitute an injury within the meaning of Article 3. That was modified in Flass versus Cohen with respect to Establishment Clause cases, but that remains non-controversial law. It also declared that a state cannot bring a parens patriae action against the federal government because in a parens patriae action you are asserting not your own rights, but the rights of your citizens, and your citizens are also citizens of the United States, and that is the paramount citizenship. That is not controversial, and it remains good law. The third thing that Massachusetts versus Mellon did was to establish modern standing doctrine. The court noted that Massachusetts had not been injured because it had not been required to do anything or give way with respect to anything. And the majority opinion says, and perhaps we could stop here. Well, if they had stopped there, you would just have a modern standing doctrine, and you would find that Massachusetts' claim was too abstract to support a 10th Amendment challenge because, unlike Virginia, which had a statute to defend, Massachusetts was just wishing to abstractly discuss constitutional allocation of powers. But the court didn't stop there. The court went and said that its fourth grounds or its fourth decision was under the political question doctrine, citing the usual suspects. So it clearly was a political question case. It was recognized by commentators writing in the Harvard Law Review right after the decision was handed down as a political question case. And so it continued being cited in the Supreme Court as dicta, usually in connection with one of the other three propositions, that there was an aspect in which Massachusetts versus Mellon was a political question case. But then in 1962, in Baker versus Carr, the Supreme Court completely redefined the political question doctrine. It did it in two ways. One, it gave a laundry list of the political question doctrine cases from which Massachusetts versus Mellon was omitted. Secondly, it said political question cases involve separation of powers between the branches of the federal government, not relations between the federal government and the states. So after that, the political question prong of Massachusetts versus Mellon no longer fitted doctrine. And not long thereafter, in 1966, in South Carolina versus Katzenbach, South Carolina challenged the Voting Rights Act of 1965 and invoke the original jurisdiction of the Supreme Court, at which time the Supreme Court said, well, Massachusetts is not bringing this as a parents patriarch case, citing Massachusetts versus Mellon. It is alleging injury to its own political rights, and therefore we will exercise jurisdiction. And so at that point, I submit that the political question prong of Massachusetts versus Mellon was no longer effective. Series of cases thereafter, Oregon versus Mitchell, states were allowed to assert their political interest against the federal government. The doctrine of sovereign state standing has been widely recognized in the circuits in cases that we cite in our cert petition. The U.S. Supreme Court in Snap and Sons and in other cases has recognized the doctrine in dicta. In Bond, United States versus Bond, last term, an individual was allowed to assert not merely separation of powers, enumerated powers issues, but actually to invoke the policy interest of the state. Although the court said doubtless there are cases where only the state would have a standing to bring this claim. So I think that we are on very strong ground. We lost in the Fourth Circuit after having won in the district court on standing. I will note the Fourth Circuit did not cite Katzenbach, and I think basically established a prudential standing rule, which I don't think has any support in Supreme Court doctrine. Where we are now is the United States moved quickly on the other 5 challenges, and so they were distributed for conference yesterday. When the United States filed its response brief, we immediately faxed a letter to General Souter, clerk of the U.S. Supreme Court, waiving our right of reply, hoping that we would be distributed on the 10th as well. We were not. We've been distributed for a conference on November 22nd, and we obviously look forward with interest to what will be done.
Hi, well, first of all, let me thank Professor Erickson, Professor Walsh, Professor Tobias, the law review staff, who have just been incredible, and for putting this together. And I want to thank the 11th Circuit, the 6th Circuit, and the 4th Circuit for making this conference especially timely. They decided it at exactly the right time. My section really isn't all that timely because it deals with the states getting involved in the process in the first place. This has really been a fascinating time to watch the states and watch what's been going on in the states. There have been conflicts in Iowa where the governor is on one side and the attorney general is on the other side. In New Hampshire and North Carolina, where the attorney general is on one side and the legislature is on the other side. And the question comes up consistently: who represents the states? So let's assume, I know I'm supposed to disagree with Duncan on a lot of things because after all, I come from a Democratic administration. I actually think that healthcare is easily constitutional, or should be, and more importantly, he went to Duke. But I agree with him. I think that federalism is under-enforced. The federal government, you all know from reading the cases, that the federal government is supposed to, we don't need judicial intervention to protect the states because according to the theory of process federalism, the states are protected by the fact that they have that they have congressmen and they have senators up there protecting the interests of the states, but we all know that doesn't work. And it doesn't work on either side. The Republicans who are so busy fighting healthcare because they think that overly empowers the federal government are busy trying to nationalize tort law. They're busy trying to nationalize property law. The question of federalism really depends on the substantive agenda, at least of the politicians. It's used when it's convenient to be used. And so now, because folks oppose healthcare, they raise the federalism argument. When they're in favor of nationalizing tort law, they don't. and the Democrats are just as hypocritical. So I think we can assume that Washington isn't going to protect state power, and I agree with Duncan that the notion of federalism and the notion of decentralizing power is essential to what our system of government is and should be. I disagree on the merits of this particular case, but this conference isn't about the merits. How do you figure out, the question that I'm supposed to deal with is, how do you figure out who is the state? I mean, who is Virginia? Right now, Virginia has it fairly easy for deciding things because the governor and the attorney general are of the same party. But let's assume the governor was still Tim Kaine, and Tim Kaine was in favor of health care. Or let's flip it. Let's assume that the governor is Attorney General Queally. He's now governor. And the attorney general is Tim Kaine. Who is going to represent the state, or who should represent the state? And how do we figure out how that should happen? And the healthcare debate has been fascinating in terms of how that's worked out. I was talking to Duncan earlier. He said in Virginia it's fairly easy. There's a pretty clear line of precedent indicating that the attorney general is the one who represents the state, but that's not true in all of the various states. What this whole thing reflects, and what I want to step back for a minute, is to talk about something that exists in the states but doesn't exist in the federal government. And that is what is known as the divided executive. Unlike the federal government, where we have one president and it can appoint the attorney general, in 43 states, the attorney general is independently elected. In 5, the attorney general is independent even though he or she is not independently elected. Tennessee, for example, the Supreme Court picks the attorney general in Tennessee. In Maine, the legislature picks the attorney general. In 3 other states, the governor appoints the attorney general, but the governor cannot fire the attorney general. There are only 2 states, Wyoming and Alaska, in which the attorney general is really dependent, is not an independent officer. And even those states have other officers who are independent. For example, the Secretary of State is often independently elected in some states. So conflicts come up as to who sets the particular policy. The reason why the states have a divided executive, by the way, traces back to Ohio, which had a very, very imperial governor. And the argument was made, this was after the federal constitution was enacted. A lot of states started amending their constitution. They thought too much power was being vested in one source. The notion of separation of powers and the idea that there was too much power in one place led the states to move on and start adopting this notion of the divided executive. In fact, in the national debate over the so-called unitary president debate, which you hear so much about, a lot of the defenders of the unitary executive said that once that model was adopted by the United States, every other government has followed suit. But that's not right. All the states have rebelled against that model because it does concentrate too much power in one person. And think about that with respect to the office of the Attorney General in particular. Imagine, for example, that you are in the Justice Department and you are responding to the fact that the World Trade Center was blown up. And the President of the United States says, and you work for the President of the United States, the President of the United States says, or one of his top aides says, if you don't give us the power we want, there are going to be another 5,000 people dead in a minute, and it's all in your hands. How do you respond? And if you're going to respond and say, well, maybe the power that you want me to authorize is unconstitutional, you will either A, be excluded from the room when further decisions are made, or B, you will be fired, or C, you will just be completely ignored. The idea of an attorney general that responds directly to the president is very manipulative. If you read the history of Korematsu and what happened with the concentration camps for the Japanese in California, Bill, the attorney general at the time, felt political pressure because he was part of the team not to stand up to the president when they were authorizing that, and that's just human nature. If you're working for somebody, you have a sense of loyalty anyway, and what you do not get, and what we certainly saw in the last administration, what you don't really get is independent kinds of standing up to executive power. And in a lot of cases, executive power is never reviewed by the courts because the decision happens too late, the decisions are made too quickly. The idea of having an independent attorney general is about as strong a move in terms of protecting separation of powers and making sure that the rule of law is upheld as other kinds of divisions that we see in government. So I'm a big fan of the divided executive. It does lead to some problems. Because how do you decide who prevails? In most states, the governor is designated as the chief executive officer. I think that's true in all states. In all states, the attorney general is designated as the chief legal officer. Okay, how do you figure that one out? When they disagree on a particular point. Is there something different? By the way, it's interesting that the federal attorney general, the first Judiciary Act, the federal attorney general, the plan was to have the attorney general picked by the United States Supreme Court and not by the president. But they moved the attorney general over into the executive branch, and I think more logically fits there. But the notion that you are a legal officer might seem slightly different than just basically executive power, but clearly there is a lot of overlap. And what we saw in the healthcare litigation, and continuously, not just in healthcare litigation, but in other circumstances, is the governor and the attorney general disagree. Sometimes, by the way, it happens because they're of different parties. That's not always true. Sometimes it happens because they're the same party, and they have different ambitions. As a matter of fact, you all know this from personal experience. Sometimes you get angry at the people who are close to you than you do on the other side, and you can work out a better relationship with folks on the other side than you do with your own party. But clearly there is a space for conflict here. The National Association of Attorneys General, NAAG, N-A-A-G, stands for the National Association of Attorneys General, although a lot of people think it stands for National Association of Aspiring Governors. AGs are often interested in the next office, and if that doesn't bring you into conflict with the person who's holding that office, what else does? So there's political reasons why there may be conflict. There are other kinds of reasons. They might see their views somewhat differently. Attorney General might see her primary allegiance as to upholding the rule of law, what they believe to be the rule of law. The governor is more focused on the policy priorities that are facing a particular state, and that could lead them into conflict as well. What's interesting, however, is how little time. I mean, given the scenario where you would think that there would be a lot of conflict, in fact, it doesn't happen all that much. And one of the things that's interesting is why is that true? Even when you have an attorney general and a governor who are diametrically opposed to each other, they have a tendency to work these things out. In part because structure is set up that way. Governor's offices usually have a counsel who work directly with the attorney general's office, so that there is a lot of work done together. And there is also, as much as there may be a political motivation for the actors to diverge, there is often a political motivation for them to work together. The governor wants to take an initiative. The governor gets more political strength in doing that if the attorney general supports the legality of the initiative that the governor is taking. So there is an incentive for the two to work together on both sides. The governor becomes in a much more precarious position if she decides to take a position with which the attorney general disagrees. So what you often get, and what you get many more times, and I think both Will and Duncan can attest to this because they are now working in AG's office, is cooperation. Particularly, there may be a lot of conflict in the private rooms. But they work it out. And they work it out because they need to work it out for the credibility of both offices. But there is conflict. And how is conflict resolved, or how should it be resolved when the two disagree? So let's move to Iowa for a minute and not stay away from Virginia and move to Iowa because the governor is Republican and the attorney general is a Democrat. And there was a conflict on the constitutionality of health care. Or let's move to Washington. State of Washington, which, by the way, I moved to in half a second, in which the governor is a Democrat who favored health care, and the attorney general is a Republican who wanted to contest the validity of health care. How do we resolve this? How should we do it? In Georgia, when there was that conflict, the governor just hired his own counsel and went into court. In Iowa, the governor just joined the brief automatically. So you can try to take shortcuts, but assume you're not going to take a shortcut and work this really through. Who should prevail? The first answer is read the statutes. Read or the constitutional provisions. There are as many types of powers given to an attorney general as there are states. It's not uniform. In some states, the AG is considered a constitutional officer. In some states, the AG just has her powers perfectly on the basis of statutes. And it may be that the statute is going to give you a clear sense of who has the power. Washington State, the particular conflict over health care produced two different judicial opinions, only two. Those are the only two that went to court. One came out of Washington State, in which the city of Seattle challenged Attorney General McKenna's decision to join the healthcare litigation. The court there did not accept the challenge by Seattle, ruling that the Attorney General had the authority to decide which cases the state should get involved with or not. Interestingly, however, although that might sound like a victory for the AG, some of the language in the opinion said, of course, the legislature can change the Attorney General's power if it so decides. In New Hampshire, what happened was that the legislature challenged or passed a law trying to force the state attorney general to join the healthcare litigation. New Hampshire is my home state. You gotta know a little bit about New Hampshire. It has 400 members of the lower house, making it the third largest parliamentary body in the English-speaking world. This is an estate of about 1 million people. Everybody is a state rep. They get paid about $100 a year. And it's a very wild and woolly kind of legislative session that takes place there. And in this particular case, it said, we're going to force the AG to take a position. The New Hampshire Attorney General's office said, well, this is easy because the legislature is trying to do this, and that is a clear violation of separation of powers. The decision of whether or not you want to join a suit is a legal decision, executive decision. The legislature's got no business forcing legislative decisions, and so they ruled for the AG on that. But their opinion also said if the governor had ordered the AG instead, that might have come up with a different kind of result. So you might get a different view on the basis of how the statutes are structured or how the constitutional office is defined in the state constitution. I have a simple answer for this. I think the AG should have the ultimate say on this. I think that's what the idea of an independent attorney general is supposed to be, that we want that check. So normatively, although you have to take a look at the statutes, normatively, I think it is correct to say that if a Republican AG, Rob McKenna, wants to join the healthcare litigation and his Democratic governor, Christine Gregoire, does not, he's got the final say because being the chief legal officer means they have the authority to do that, and the notion of separation, the notion that the reason why you want an independent AG is to check against the excessive powers of the governor, gives policy reasons to suggest that it is the AG that should have the final say. So I think that's what it should be as a normative result. Again, it might depend on statutes. One of the interesting things that happened here, one of the things in the litigation is that there was a lot of caution about either party wanting to run to court between governors and AGs because neither side might be happy with the particular result. And so we didn't see the actual litigation take place precisely for that reason, and they tried to work it out. And this would have been a very strange case for powers of AGs and governors to really be tested, which leads me to my final point. One of the interesting things about the New Hampshire litigation is that when the legislature went to the Supreme Court, they said, we'll give the AG the right. The AG wants to decide to initiate criminal prosecution or civil prosecution. That's one thing. That's a legal decision. But what this is, deciding to join healthcare, is a political decision. This is what they call policy-based litigation. Not really a legal decision, much more of a policy choice. And for that reason, maybe it should be a legislative matter. The question that comes up to my mind is, should attorney generals or governors, for that matter, be engaging in litigation on the basis of policy or politics and not on the basis of law? I mean, it's really been fascinating to me as this litigation has proceeded through that you see a lot of headlines that 26 attorney generals have joined a particular litigation. And my response is, so what? What does that have to do with the legality of healthcare? It seems to me that if there was one person opposed to healthcare in the United States and had standing, and everybody else was in favor of healthcare, if the law was that the healthcare was unconstitutional, it should be unconstitutional. And whether 3 states are against it, or 20 states are against it, or 50 states are against it, doesn't make any difference. But what we've seen in the healthcare debate, and again, I support the legal arguments raised by some, but what we've seen is an over-politicization of the process. And so much of this litigation has nothing to do with the legal merits. The same people who are arguing no federal power here have been arguing in favor of federal power elsewhere. By the way, historically, take a look at the background of when Social Security was passed. You saw cries of socialism taking place at that point, too. The more things change, the more they stay the same. And particularly a lot of these debates that were going on at the state level were just one upmanship on who can make a political point. Justice Scalia, Judge Posner, and others have seriously criticized the amicus process as being nothing more than political attempts or political efforts that have nothing to do with the law in question. And so whereas I think the AGs have power, and whereas I do think that there is a legitimate role here for AGs to question the overreaching of federal power, I've become a little bit concerned about the way this particular litigation is played out, with folks just wanting to be counted to make a political point and not because of the merits of the legal claims that they're presenting. Thanks.
Morning. I want to start by thanking the University of Richmond Law School and the Law Review, Professors Walsh and Tobias, and especially Amina for her patience in my delinquent emailing back with the important materials I was supposed to be submitting weeks before I actually did, that sort of thing. I also want to start by apologizing. I won't be able to match Duncan's zeal, I don't think, in my presentation. It's been my shortcoming as a lawyer from the very beginning that the zealous advocate part is the part that I do least well at. The part I do best at, I think, is candor to the tribunal, and that's why I'm making these disclaimers out of candor. Same candor compels me to say that I can't match Professor Marshall's erudition for my remarks, which are on the role of states as amici curiae in litigation generally, in the Supreme Court more particularly, and in healthcare litigation more particularly. Now, another disclaimer, my observations and views on this subject come from my experience as an Assistant Attorney General in the state of Maryland, and to some extent from my role as a Supreme Court Fellow at the National Association of Aspiring Governors Supreme Court Project. He stole my line, but it's probably used as often as the acronym is explained. Although that is the basis for my remarks, I do need to say that these are my views, not necessarily the views of the Attorneys General I've served under, or our clients, or the National Association of Attorneys General. A final disclaimer, and then I'll be done with all the throat clearing. I'm here with two co-panelists who have equal, if not greater, experience with the topic that I'm discussing. I hope they'll feel free to jump in, and I hope also that the audience will, that this will lead to a productive discussion in the question and answer session. So in the CLE handout that I've provided, I've provided citations to the relevant provisions of the Federal Rules of Appellate Procedure and the Supreme Court rules, which recognize a special role for states as an AP in the appeals courts and in the Supreme Court. Some of the special provisions made there are just to accommodate the unique situation of the states. The disclosure requirements required of other MEP are less workable when we're talking about 18 attorneys general say on a brief, and they don't want to have to disclose all of their memberships in the National Rifle Association, all the rest. But some of them are a recognition that the states do have a unique contribution to make in the resolution of the kinds of issues that have come to the appellate courts. And so, for instance, the states needn't seek consent to file an amicus brief in the appellate courts or in the Supreme Court. We just provide notice that we will be doing that. Now, in the healthcare litigation, we learned that the trial courts have a different view of amicus participation, and so a group of the states that have written amicus briefs in the various lower courts that have been taking up the healthcare constitutional challenges all began by preparing an amicus brief to support the United States motion to dismiss in the Pensacola, in Northern District of Florida in Pensacola. The trial judge there said, I'm not looking at amicus briefs at the motion to dismiss. And so we did file one. We did file a summary judgment. I think at that time we had 5 states, Maryland, Oregon, Vermont, Iowa, and Kentucky, which I didn't join any subsequent days. So that raises the question, why participate as an amicus? And I think a big part of the reason is because of the unique role that attorneys general have as attorneys for institutional litigants. Just as the professional rules of ethics recognize that public lawyers have a slightly different duty to their clients, they needn't as zealously advocate the interests or the wishes of their clients. They may make an independent determination about the interests of their clients and take a broader view of who their clients are. So it isn't just the governor, it isn't just the Maryland General Assembly or the Secretary of the Department of Health and Mental Hygiene in Maryland. It's the people of the state of Maryland and consumers in Maryland and that kind of thing. And so that often leads to the kind of divergence of interest that Professor Marshall was talking about. That same capacity as institutional litigants, I think, explains partly why the states feel compelled to participate in amicus briefs, especially at the Supreme Court, but also in lower appellate courts and sometimes in trial courts. And the reason, I think, is that unlike many private litigants, let me just take a step back and offer a hypothesis that most practitioners, I think, have a pretty good understanding of what goes on in trial courts. They know the inputs and they know the outputs, and they have a little bit of an understanding of what happens between the input and the output. There are rules of evidence. You have fact witnesses whom you can't seem to control. You have expert witnesses who you can't seem to dislodge from the control of your opponent. So you have that testimony, you have facts, you have legal argument, you have rules of evidence, and you have a judge making rulings. And you see most of that. In the appellate world, you don't. You have a trial court record, you have 3 briefs, sometimes 4, and then the amicus briefs, you have an oral argument, typically, and then everything disappears into a black box, and two things emerge from it: a ruling, a disposition of the appeal, and reasoning for it. You hope that you are provided the reasoning. You're not always. And whereas I think lawyers for many private litigants are most interested in that disposition of the ruling, public lawyers and institutional litigants may be more interested in the reasoning than in the ruling. You know, we can live with a defeat here or there, but if the reasoning is going to lead to a series of defeats on important matters in future cases, that's much more distressing to us than just losing in one case. And of course, the appellate courts are where precedents are set, and those precedents tend to determine the course of future developments in the law. And so if we have an opportunity to influence that process, we want to take it. Are amicus briefs influential? Well, I mean, I think as Professor Marshall has said, you know, there's some sentiment that the huge volume of amicus briefs that the Supreme Court in particular sees now is not necessarily helpful to those justices believe to their resolution of the issues on appeal, and a lot of it seems to be, you know, there are lawyers out there who want to be practicing before the Supreme Court and have clients they can convince to pay for briefs. Briefs are, you know, appellate briefs are cheaper than trial court litigation, so it often seems like a pretty good bargain. And, you know, you can say, I made my views known in the Supreme Court in this very important case for my business or whatever. And there's a sense in which I think a lot of the amici there, including sometimes the states through their attorneys general, are really just sort of like taking sides so that they can be recorded as having been on one side or the other of a legal dispute that has sort of public resonance. And I think if that's all the brief accomplishes is to allow the justices to count noses, it's not a very effective brief. And so that is a consideration, I think, that states and their attorneys general take into account in deciding whether to join briefs. So that's a little bit about why participate. And if there's a question about the influence of amicus briefs, there's, I think maybe probably the case where you first saw just a real cavalcade of briefs being submitted was in the Grutter and Gratz affirmative action cases involving the University of Michigan undergraduate and law programs. And that was actually also the first brief I worked on when I came to the Attorney General's office. Maryland and New York co-authored a brief in that case. And at oral argument in that case, Justice Ginsburg spent a lot of time questioning the Solicitor General about a brief that had been submitted. I think Virginia Sykes and Carter Phillips were the lawyers in the case, but it's on behalf of retired military officers who said that it's very important to be able to give some sort of a plus factor to minority applicants to the military academies in order to build not only a diverse enlisted ranks force in the military, but also to have a cadre of officers who represented the United States population as a whole, and they talked about the military benefit of that more diverse officer cadre. Since then, we've seen several other cases that have just attracted way too many briefs, even for the justices who are, I think, authoring the opinions to really fully digest. And that's not really a bad thing necessarily, because so many of those briefs are duplicative. The other more recent example is in the Heller DC Second Amendment case, where there were, I think there must have been at least 100 briefs submitted. But they do, I think, influence the court, and I think states' amicus briefs do in particular cases, because states can offer their perspective on practical implications of a particular rule urged by one of the parties. And that's a concern to the justices, and I think to some justices more than others. I think Sandra Day O'Connor was famous for making her clerks do 50 state surveys, and if you can do that for her in your brief and talk about how many state laws might be affected by a ruling in a case involving a federal statute or a federal criminal proceeding, I think that those practical implications are ones that, being the court of last resort, the Supreme Court wants to take into account. So what are the kinds of cases where the states view themselves as having a fairly direct interest in I think states line up pretty uniformly in support of the United States and of their sister states when we're talking about a criminal case. So when there's a Fourth Amendment, Fifth Amendment, confrontation clause, self-incrimination, and that sort of thing going on, most states will view it as being in their interest to support the prosecution standpoint. Sometimes Maryland, for instance, will abstain in those briefs because our Court of Appeals is sort of the Ninth Circuit of state high courts in its approach to criminal practice and procedure, and so we've already been living under the kinds of rules that the United States is still combating, and it's hard for us to say that we can't do our jobs under the rule, so it's better for us just to stay off the brief. That's an exception. And then, a large part of the Supreme Court's docket is stuff that is really peculiar to federal criminal law, sentencing guidelines, and that sort of thing. And there isn't a great interest among the states in weighing in there. We have a real interest. I think this is one where the states really don't divide in maintaining doctrines of official qualified immunity. And then the other major area and more relevant to the topic today is cases that present issues involving federal-state relations. The one that's actually most important, I think, to our office's practice right now is preemption. Whether federal statutes or even worse regulations are construed to displace or preempt state regulations and laws, and the states have taken a pretty coordinated approach to arguing against a broad doctrine of preemption, and there's been some very unique and I think effective strategies undertaken in that area. Another federal-state relation area is the role of federal courts vis-a-vis the states. So 11th Amendment cases. Maryland actually has a case before the court right now where we're the respondent. We didn't ask for this to go up, but it deals with the 11th Amendment and whether Congress validly authorized suits for damages against the states when it enacted the self-care provisions of the Family and Medical Leave Act. We know from Nevada versus Hibbs that the family care provisions do aggregate sovereign immunity for suits for damages, but it's another question that will be resolved in this Coleman versus Maryland Court of Appeals case. Another federal court, vis-a-vis the states issue, and I may be the only person here who's more interested in the order list on Monday for cases other than healthcare, because we have a petition pending in a case where the federal court in Maryland has insisted that we have to remain subject to a 30-year-long or 20-some-year-long consent decree where the plaintiffs who brought it 20-some years ago were proceeding under causes of action that are not actually created by the statute that it was believed that supported those causes of action. Subsequent Supreme Court law has made that clear, and yet we're stuck running Baltimore City's foster care program to the satisfaction of the federal court, or more precisely, the plaintiff's attorneys, rather than to the satisfaction of the Secretary of Health and Human Services and to political leaders in Maryland. And that's the way the statutory scheme is actually designed to work. 10th Amendment is another federal-state relation area, and of course that adds some relevance to the healthcare debate too. So there are also times where the interest of the state is a little less direct, and we are, I think, playing with that line between a legal decision and a policy decision. Where the impact on the state in future litigation is remote or very attenuated, but you do want to line up and say, no, the policy of the state of Maryland is to support, say, the viability of state law causes of action for intentional infliction of emotional distress, where a group of inbred members of a congregation in Kansas show up at funerals to issue sort of Tourette syndrome non sequiturs designed to attract attention to their message, which is, on a matter of public concern for the most part, but which does inflict emotional distress for the same reason that they seek public attention for their message by creating that emotional distress. 48 states, I think, joined an amicus brief, unsuccessful, as it turns out, in the Supreme Court in the Snyder versus Phelps case last year. So another one, I think this is very interesting. 30-some states, I think, joined a brief in the follow-on Second Amendment case to Heller, and that was the question in McDonald versus City of Chicago, whether the Second Amendment was incorporated as against the states as well as against the federal government. And it's one thing, I think, to say that we as a state support gun rights, but it's a little bit strange to be essentially inviting new arguments for post-conviction relief by your prisoners and habeas petitions by your prisoners, and then to invite also challenges to your own gun control statutes, providing a whole new legal theory for that to be done. It's also strange, I think, to be essentially telling the court that you don't believe your citizens can be protected from your state government. Their rights aren't protected, especially where most states, I think, have analogs to the Second Amendment where the text is actually a little bit easier to decipher. I see I'm into the question and answer period, so I'll conclude my remarks there, and maybe some more will come out in that discussion.
Thanks so much to all of our speakers for offering their insight into this interesting issue. I'm going to open it up now for questions from the audience.
So I have a question for General Getchell. Well, I guess it's kind of a two-part question. First question is there any limit, in your view, to any statute that a state could pass, essentially declaring that a federal statute regulating that state's citizens is inconsistent with the state's law, and that would be sufficient to generate a standing? So this argument would extend to any as I understand it, would give Virginia standing to pass any law that would interfere with any regulation. And then the second question is, does there really even need to be a statute, a state statute? Suppose Virginia disagrees with the federal government's regulation of some pollutant, and Virginia makes a very conscious decision not to regulate it at the state level. And Virginia wants it unregulated within its borders. Is the federal government's decision, contrary to that, to say regulate it pursuant to the Clean Water Act, also the same, generate the exact same sovereign injury that is interference with Virginia's enforcement of its law, which is a law of non-regulation, which then gives any state standing, injury in fact, to go to court to litigate. So there doesn't even need to be a Virginia Healthcare Freedom Act. Really, any time Virginia thinks federal law, federal regulation of an individual is inconsistent with the policy of Virginia, as expressed in its statutes, either explicitly or implicitly, it has Article 3 standing to get into federal court.
With respect to the first question, modern standing doctrine doesn't have anything to do with the merits. The court made it clear that regardless of the merits, the issue is whether there's a claim injury that's traceable, justiciable. And under those circumstances, it is our position, we still argue it for certain, that yes, in theory, that we could challenge the federal government by passing a law contradicting federal legislation, which is clearly within the competence of congressional law, which would simply create standing to lose. And although I think the Fourth Circuit has turned that into a prudential argument, using your argument, a prudential limitation on state standing, I don't see how intent or staying about who has the power really affects state analysis on standing. So I would say we would have standing either to win or lose. And although I think the Fourth Circuit dropped a footnote rejecting the standing to lose notion, in the argument in the United States versus Bond, Justice Kagan made that very point. That of course you have standing to lose. With respect to the second question, I would have said that I would not have talked about creating standing before Bond. The act that became the Virginia Healthcare Freedom Act, I believe, was drafted by a conservative think tank. I don't know what their intent was. We viewed it after it passed as putting us outside of Massachusetts versus Mellon, and so argued. Since Bond, I would think that a collision with a policy may well be enough, because remember what Mrs. Bond was permitted to argue. She was permitted to argue Pennsylvania, even though there was no direct conflict between a state statute punishing the same conduct and a federal statute punishing the same conduct because of the sovereign doctrine. That the fact that Pennsylvania punished the conduct much more leniently was a state interest that she was permitted to derivatively assert. So I would think that now any clear collision between the sovereign interests would support standing and standing.
Question for Professor Marshall and Duncan Getchell, with keying off of what General Brockman said. So there is an important difference between an amicus and a party. And although I do think amicus can be very consequential, I thought it was particularly courageous of Virginia's Attorney General not to join the amicus in the Snyder versus Phelps case, because there is this bandwagon effect. But one difference between an amicus and a party is that the party's bound by the judgment in the case. And so thinking of it from the perspective of the federal court and saying who's going to be bound by this judgment, sort of here's the two questions. One is for Professor Marshall, why should it always be the AG who's allowed in if that judgment is going to affect the responsibilities of the governor. So for example, the Washington experience in the Florida versus HHS, where that decision, that judgment resulted in an invalidation in its entirety of the Affordable Care Act, including Medicaid provisions, including all sorts of things that the governor was charged with administering. And that governor presumably then faced a choice to continue implementing the act, and that sort of never came to a head because I think the district judge realized what a mess had been created and issued a stay of the judgment. But there we have this sort of problem where the party whose conduct we're interested in controlling isn't before the court. So why should it be the AG if we're not concerned about binding the AG? For General Getchell, it's a different point, which is why wasn't the Virginia case seeking an advisory opinion? That is, if we think about who the district court judgment would bind, and it would just be Virginia and the federal government. Virginia is not subject to the individual mandate. There's nothing that district court decision did to change the legal obligations of anyone who's subject to the individual mandate. So it had no effect on the Liberty University case. The only way to do that would be an injunction against the federal government saying don't enforce it against our citizens. But then that's a parent's patriae claim because you're trying to protect them. Each of you could focus on the effect of the judgment these particular problems faced by states and litigants.
Sure. I mean, when a lawyer makes a decision, when a lawyer of an entity makes a decision, it's going to affect that entity. And it will affect everybody who works for that entity, whether it be the governor or whether it be anybody else, the health department of that state. My argument is that the AG is the one who is properly charged with determining legal interest. The Attorney General, in deciding that, should take a look at the issues you talked about. And if they don't, they aren't doing their job in the way that they should. They are not representing their client, that is the state of Washington, in a way that they should if they are ignoring critical factors. But it is the AG that is empowered or should be empowered to make the legal decision in the first place. I mean, your argument can go so far as to say that anybody in the state of Washington affected by this decision should be able to have a representation in the Florida courts too. But I think that the idea is that the state is one entity and who represents the state should be confined to one entity. And I think that the logical reason for that under this notion of the divided executive is that should be the AG.
And before Duncan addresses the advisory opinion question, let me just build on that with an anecdote. Within a few days after joining the AG's office, about 9 years ago, I was speaking very casually and referred to the governor as the boss, and about 4 people wheeled around in the hallway, aghast, and a couple came out of their offices and said, no, he's our client. Our boss is the AG. And it's a distinction that we adhere to very closely, but it remains the fact that the governor is our client. And if we didn't consult him, or couldn't take into account the repercussions of our legal position on his duties to, execute the laws, I think we wouldn't be doing our job. That said, with the caveat that I made earlier, that public lawyers have, I think, some greater latitude to depart from the precise wishes of their clients in order to pursue what they believe to be the interests of their clients. In the healthcare situation, we're lucky right now not to really have to grapple with those issues. And in fact, because the Attorney General has a legal position that coincides with the governor's policy position, I think we're able to make a different and better legal argument in our amicus briefs because we can talk about the practical implications of implementation and the practical problems that we believe federal health care reform helps the states to address. and we can consult our clients to really get a better understanding of that. So, sorry for jumping in.
The reason that it's not an advisory opinion is because Virginia is being required to give way. It has passed an act which it desires to enforce as an exercise of the police power over the same citizens that the federal government has. If the federal government has exceeded its enumerated powers, our police statute is valid. If they are within their powers, then obviously our statute has to yield to the supremacy clause. But we have an actual sovereign injury because we have a statute which we wish to preserve. And I believe that an interesting observation can be made that everybody, the Solicitor General, the Fourth Circuit, in its opinion, recognizes that they regard the Wyoming ex rel. Frank case as being good law on sovereign standing. Well, what happened in Wyoming was that Wyoming had passed an act which expunged records. And the federal government had passed a regulation, or maybe only a statement of policy, that said we're not going to recognize the Wyoming definition of expungement. We have a separate federal definition of expungement. And Wyoming brought a declaratory judgment action seeking a declaration that its definition should apply to federal background checks. Now, if your argument is correct, that we're seeking nothing but an advisory, the same argument will apply equally to Wyoming, and nobody thinks it does.
Well, I mean, I guess the question there is you know, what Professor Walsh was asking is like the terms of the judgment. How will that constrain if the district court had come out the other way and there'd been a ruling not appealed against Virginia? In what way would anyone be bound not to do or to do something?
Right now, if the Virginia statute is valid, nobody, with the exception of enumerated exceptions, can require anybody to have insurance in order to be employed, nor can any benefit be withheld or account of the status of being uninsured. That would be enforceable against anybody by injunction brought by the Attorney General. And although Virginia is a at-will employment state in general, it has a public policy exception. And anybody who was required to have health insurance as a condition of some good or benefit with or employment at least, if they were discharged for not having it, they would have a private cause of action. So the interest of Virginia is creating these legal mechanisms over its own population, and it will necessarily have to give way in that regime if the federal law is out.
I want to go back to a little broader answer to your question, because let me tell you the weakness in my argument. The weakness in my argument is some of the Attorney Generals are acting with the rule of law in mind. And what we haven't seen in this healthcare litigation is Attorney Generals acting with that. I don't know any Attorney General on the side of upholding healthcare who is politically in favor of healthcare. I don't know any Attorney General in favor of striking down healthcare who is not politically against healthcare. It seems that people's legal position is completely following their political position. I think Attorneys General should be held to a higher standard than governors when it comes to taking the position that is legally required, what they believe is legally correct, whether or not it's politically consistent with their view.
Could I follow up? Interestingly, the Attorney General of Virginia has recently published a piece in the Washington Post, in which he says that the attempt by Congress in the Republican Jobs Bill to nationalize medical malpractice and tort reform is unconstitutional. And he has said that he would sue if that were enacted with the same alacrity that he sued over healthcare, although as a matter of policy, he is in favor of tort reform at the state level.
I have a question for Professor Marshall. It's in response to your comments about why it might or might not matter that the states file lawsuits themselves as parties in a case where it's certain that some individual somewhere was going to be opposed to the healthcare bill and suffer some harm and eventually file a suit him or herself in such a way that the Supreme Court would decide the merits. Whether, I guess my question is whether it might actually matter in a very practical way whether the states are parties themselves. I guess both in the question of whether the Supreme Court would agree to hear a case where a state wasn't a party as opposed to a case where 26 some states were parties, but then also in the actual outcome of the case. And I think, for example, whether the Supreme Court would be more likely to sever the individual mandate from the Medicaid provisions that directly burden states in a suit brought by an individual, as opposed to, how they would decide that question in suits brought by states, and whether there actually is a practical impact of that.
Yeah, when I sat down, I realized that when I made my comment that was a flaw that I should have done. I agree completely with Will that there are times when an amicus brief from the states are very important. In fact, everybody on this stage knows that when there's a case goes to the United States Supreme Court, one state will come forward and say, we'll write the amicus, and then they call around to every single other state to get them to join. It's this incredibly interesting process that takes place, and states like to try to partner with other states in doing it. There is a perspective that I think is valuable. One of the most famous amicus briefs of all time was written by then Attorney General Mondale supporting Gideon in Gideon versus Wainwright, which was something for an Attorney General to say, and somebody should have a right to counsel. And I do think that states have a particular perspective. The point that I was trying to make is so much of what is going on here isn't states coming in to present a particular perspective as much as it is people saying, I want to be counted as being opposed or in favor of health care. And I think that's particularly true with the governors and with the state legislators who file separate from the state's own interests.
I will point out, however, that if you concede as you do, that the states have a historical role in checking federal policy. Our founders famously said that checks and balances is going to work by opposing interest against interest. And because every interest involved is that of an elected official, there is an irreducible amount of politics that will be in this, but it still remains a valid undertaking.
Well, but there's a question of law versus politics. There's a question of if you're just trying to use the judicial system to make a political point. And then I think that's different than using the legal system to present a legal argument and to present the legitimate interests of the states that might be involved in any particular issue. But what I think we've seen a lot more is politicization of the process. And where people are just using these briefs, or using what they can to get up and say to their constituency, I filed in favor of health care, or I filed against health care, without really caring about the underlying legal issue. And that's what I think is irresponsible. There's some who care about the underlying legal issue, and there's some who see that as secondary only to an overall political marker that they want to lay out.
And now, I don't want to criticize anybody else directly or by implication, but with respect to our suit, defending our statute in our federal court, I believe that what we have filed is very substantial.
I'm not criticizing the Attorney General.
And with respect to the other two, your question asked about the Medicaid expansion and employer mandate. Those issues, apart from the individual mandate, are are ones that I think everybody would agree the states have an interest in, even if you disagree that the interest runs in the direction that they've argued. But and that I think is a very curious part of this this whole healthcare litigation in the public sphere, which is that by having 26 states through their attorneys general or through the governor supposedly speaking on behalf of the people and that sort of thing, it raises the profile of a particular argument, the individual mandate argument and the inactivity versus activity distinction. And it's curious because I think that argument has a lot of rhetorical power and political traction, but I think the reason is because it taps into notions people have about individual liberties, which is really more of a due process issue. Now, I know, as Duncan points out, that Bond recognizes that the structural limitations that are built into the Constitution also serve to protect individual liberties, but the principal function of the Commerce Clause, which is the basis for the challenge here, is to allocate regulatory power over commerce between the federal government and the states. And I think that's one reason why the states can provide a very useful perspective in amicus briefing, because they can say how it is they conceive of that allocation. That's what we've tried to do in our briefs, is to say that we think the founders anticipated that all of the enumerated powers in Article 1, Section 8 were designed to address collective action problems where the federal government could do what the states acting individually could not. And we think healthcare reform, or comprehensive healthcare reform, is one of those areas, and that the model that the ACA represents is actually a laudable example of cooperative federalism. So the idea is to return the Commerce Clause doctrine to the Commerce Clause considerations. And the states are actually, although people have criticized the states for becoming involved in bringing individual mandate claims, there is a sense in which the states are uniquely positioned to address those claims.
There is a academic discussion right now in which the point is made that you should understand the enumerated powers as you express it, because of an early resolution or report in the convention. The now 28 states that are challenging would say no, that's a functional understanding of what led to the actual enumerated powers, and the actual enumerated power of regulation of commerce should be read in light of the negative outer limit, apparently to us imposed by Morrison, in which the Supreme Court said we have always rejected readings of the Commerce Clause and of federal power that are equivalent to a national police power. And so our argument, which we think is very modest, is that if there is not a principal limit on the claim power to require a citizen to purchase a good or service from another citizen, then that exceeds the outer bounds.
Yeah, and I know we're not supposed to be talking about generic. I think those two positions can be reconciled, and it's just a matter of how you actually come out. I don't think either side disagrees, as you say, with the functional understanding of how the powers came to be enumerated, and then the limits that courts have imposed as a result of the enumeration.
I'd like to thank our speakers. We're out of time, but I'd like to thank our speakers.